I am Lorenzo, Salazar, Deputy Attorney General at the Court of Appeal of Naples, and I, personally, negotiated the European arrest warrant when I was serving at the permanent representation of Italy to the European Union in Brussels in the early 2000s. I have been asked to talk about the European arrest warrant, but it is not possible to discuss the European arrest warrant without first looking at what preceded it, namely the extradition regime. Judges of the member states of the European Union, even after the entry into force of the Treaty on European Union that created the European Union, continued for many years to apply the European Extradition Convention of 1957 of the Council of Europe, along with its protocols, until the new regime came into effect at the dawn of this millennium. The two extradition conventions adopted by the European Union in the mid-1990s, following the entry into force of the Treaty on European Union, did not replace the regime of the European Extradition Convention of 1957, but rather supplemented its provisions, enhancing its content while seeking to simplify its implementation. Some elements of true novelty were introduced by the Convention implementing the Schengen Agreement in 1990, which established provisions for simplified procedures, but above all, brought with it the creation of a database, the Schengen Information System, containing all information related to wanted persons for traditional purposes within the states adhering to the Schengen system. Therefore, the inclusion of any name in that database equated to a request for provisional arrest for traditional purposes. It is a system still in force today with the European arrest warrant that deserves to be remembered. On one hand, the European Commission immediately began working to implement the requests of the European Council from October 1999 through the adoption of a program of measures for the implementation of mutual recognition. On the other hand, a new and triggering factor intervened with the terrorist attacks in September 2001, which led to a response with the provision of new, more updated tools, such as the framework decision on the criminalization of terrorist conduct, the establishment of a judicial cooperation unit called Justa, and in particular the adoption of the framework decision on the European arrest warrant, which was negotiated in just over 8 weeks. It should be noted that Italy was the only country to oppose the adoption of this framework decision until the very end. Only a meeting at the level of prime ministers in December 2001 helped to unlock the situation, allowing for the final adoption of Framework Decision 2002-584, GALI, concerning the European arrest warrant on June 13, 2002. That framework decision has remained essentially unchanged from 2002 to the present. The only slight modification was introduced in February 2009 with Framework Decision 2009-9299, which introduced a more articulated and specific regime for proceedings in absentia, that is, those conducted in the absence of the person. What are the key points that characterize the framework decision on the European arrest warrant? This is primarily a judicial decision that no longer recognizes any role for the political authority, the minister, who normally has and continues to have the final say on matters of extradition. The European arrest warrant is a judicial decision made between judicial authorities without any possibility for political power or political authority to intervene. The European arrest warrant also leads to the abandonment of the principle of dual criminality, meaning the necessity for the same act to be defined as a crime by the legislation of both countries. There is a long list of offenses, specifically 32 as outlined in the framework decision, for which the judicial authorities of the executing country cannot question what has been established and certified by the authorities of the issuing country. This refers to the correspondence of the offense in question with the offense for which they are proceeding and for which they have issued the European arrest warrant. The third key point is the grounds for refusal are limited. 3 mandatory grounds for refusal and a series of optional grounds for refusing the European arrest warrant. The issue of the surrender of citizens is also resolved, as it opens up the possibility that subsequently a person may be returned to their state of citizenship or residence for the execution of the sentence. However, this cannot preclude the surrender of citizens, as is normally the case in extradition regions. There are also specific timeframes set for the execution of European arrest warrants and for the subsequent execution of the surrender. And finally, last but not least, the adoption of a single form for the European arrest warrant, obviously translated into all languages, makes it easy to fill out and significantly facilitates and streamlines the translation process. The framework decision that was implemented by Italy with delays and in a very problematic and controversial manner, reflecting the hostility towards the framework decision that also characterized the negotiation period. Italy intervened with Law 69 only in 2005, about over a year after the deadline granted to the states to implement the framework decision. The controversies that preceded the new legislation, along with the arguments put forward in support of the thesis that the framework decision was in conflict with our Constitution, have led to a text that presents significant criticisms, particularly regarding a series of points. All 32 specific offenses for which the principle of double jeopardy is abolished have been rewritten. They have been rewritten using language that aligns with Italian legislation, whereas the framework decision merely states types of offenses. The Italian legislator has rewritten them. All mandatory grounds for refusing the execution of the European arrest warrant have been provided. A prohibition on the extradition of Italian citizens has been established when there is a suspicion of ignorance of the legislation of the issuing state. A series of additional documentation requirements have been requested, including a report on the alleged facts, the text available by law, and other detailed elements not provided in contradiction with the decision here. All of this has resulted in the law presenting extremely problematic aspects in the text adopted by the Italian legislator. Before examining how domestic jurisprudence has responded to these critical issues, I would like to briefly review the case law of the European Court of Justice, which, as I mentioned earlier, has addressed all the main points of Decision 4. Without going into the details of individual rulings, I recall that the Court of Justice has provided a definition of the notion of judicial authority, clarifying what should be understood as judicial authority, which includes the public prosecutor, while excluding police authorities and ministerial authorities regarding those entitled to issue a European arrest warrant. The Court of Justice has indicated that one of the principles that should guide the issuing authorities of the European arrest warrant is the principle of proportionality, affirming the necessity for this principle to be taken into account by the issuing authorities, while at the same time precluding the executing authority from conducting a review of compliance with this principle of proportionality. It is solely up to the issuing authority to take the principle of proportionality into account before issuing a European arrest warrant, and thus to avoid issuing European arrest warrants for minor offenses that do not justify such measures. However, the executing authority, that of the country receiving these warrants, cannot refuse to execute a warrant on the grounds of an alleged failure to respect the principle of proportionality. It is solely up to the issuing authority to take this principle into account. The necessity to respect the execution terms, the principle of genuine cooperation between judicial authorities, the need to take into account the periods of pretrial detention served while awaiting the execution of the warrant, the strictness of the list of grounds for refusal, the principle of ne bis in idem in the interpretation and reading provided by the Court of Justice is finally very important. The relevance of any potential violation, possible violation of fundamental rights in the issuing state as a possible cause for the refusal of the European arrest warrant. On this specific point, I recall that the Court, while indicating that it is essential to avoid any concrete infringement of the fundamental rights of individuals subject to the European arrest warrant procedure, stated that this condition must be verified on a case-by-case basis by the authorities of the executing country. Therefore, even in cases where detention conditions are generally reported as problematic in a member state, the decision of the executing judge must be based on objective, reliable, precise, and appropriately updated elements, as stated by the Court, which demonstrate the existence of systemic deficiencies, specifically in the detention centers where the individual will be held. Where this cannot be established, the authority cannot automatically refuse the execution of a European arrest warrant. And finally, the Court also addressed the issue of Brexit, the United Kingdom's exit from the European Union. When an Irish court questioned the possibility of executing a European arrest warrant against the United Kingdom before it had officially exited, but while the Brexit procedure was already underway, the Court of Justice stated that it must execute European arrest warrants, as any potential refusal to execute would correspond to a unilateral suspension of the framework decision. In summary, the Court of Justice has steadfastly defended the principle of mutual recognition while always paying close attention to the issue of protecting fundamental rights, but without creating any automatic mechanisms that would lead to refusals. Similarly, Italian national jurisprudence, when compared, I repeat, with particularly problematic domestic legislation, has also sought to ensure the functioning of the mechanism without ever arriving at automatic mechanisms that could potentially lead to refusals. The jurisprudence of the Court of Cassation has essentially adopted the principle of conforming interpretation that the Court of Justice of Luxembourg established in the ruling known as Pupino. In fact, the jurisprudence of aggression has been inspired by the principle that it is not required for the legal system of the issuing state to provide the same guarantees as the Italian legal system, both in terms of procedure and in terms of pre-trial detention and every other aspect of the internal procedure. The existing differences between the legislations of the countries, in the absence, of course, of procedural harmonization at the European Union level, cannot in themselves justify refusals in assistance. This is particularly true for pre-trial detention terms in which the Court of Cassation has consistently refused the possibility of rejecting a European arrest warrant because there is no equivalent pre-trial detention regime to that of Italy. Any implicit time limit related, for example, to the fact that there is a periodic review by a judge of an individual's situation has been equated by the Court of Cassation to a situation in which the fundamental rights of the individual could be guaranteed and therefore execution could take place. Regarding the impartiality of the judiciary and prison conditions, the jurisprudence of the Court of Cassation has always, in line with what the Court of Justice indicated, avoided automatism. The mere presentation by the defense of problematic elements is not sufficient and cannot lead to a refusal to execute the European arrest warrant when such presentation is not accompanied by the demonstration of a concrete level of danger. Of course, this domestic jurisprudence has served to ensure the functioning of the mechanism until very recent years. However, the issues presented by the 2005 legislation could not escape the European Commission, which indeed initiated an infringement procedure against Italy, notifying a letter in December 2020 that contained all those issues we have referred to multiple times. This has led, as we know, to the adoption in February 2021 of a legislative decree that profoundly modified the law of 2005, particularly by removing the listing of the 32 offenses and providing a whole series of now optional grounds for refusal while maintaining the mandatory ones only for the 3 cases provided by the framework decision on the European arrest warrant. These fundamental points of the 2021 reform also touched upon other procedural changes, etc. This is the end point, I repeat, where we find a situation in which the success of the European arrest warrant, the most successful implementation of the principle of mutual recognition to date, is evident. This success has been contributed to by the national courts, particularly the Court of Cassation, and the excellent collection of case law compiled by the Office of the Court of Cassation, especially by colleagues Amicis and Calvanese, who curated this collection, where you will find in detail all those rulings to which I had to refer in a very superficial manner. It is due to the commitment of national judges, the commitment of European judges, and also the commitment of our legislator, who, albeit with significant delay, over 15 years, has finally made it possible to amend the legislation in line with the dictates of the framework decision, while always ensuring maximum attention to the respect of the fundamental rights of individuals involved in European arrest warrant procedures. National courts and European courts have avoided automatic mechanisms in refusal processes. It is necessary to examine each individual case submitted to the attention of our judicial authorities on a case-by-case basis. For the future, we will see what happens. There have been calls from various quarters to intervene on the framework decision of 2002. In the current political climate, I personally express some doubts about the possibility of expecting an improvement in the event of a potential intervention by the European legislator, given the current atmosphere prevailing in this Parliament and also in the Council between the 2 co-legislators. We will see what happens after this year's European elections. However, I can only conclude by expressing some doubts about the necessity of intervening in a mechanism that currently works excellently, a mechanism that would be very difficult to improve, at least in the near future, through a new intervention. I thank everyone for their attention. Send my best regards.